This is Bruce Rivers. Welcome to another episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board certified criminal defense lawyer. Today we're reacting to the testimony of Alex Murdaugh. But before we get to that, guess what? This episode, like all of our episodes, is brought to you by eSign.com. eSign.com is an effective way to remotely do business. So, for example, if you've got somebody else in another location, can't get together, you email them, document, you download the app, you got 3 free signatures a month, and you can do business quickly, easily, efficiently, and it can be any kind of document. I use it all the time for retainer agreements, especially when my client's out of state or they can't make it to the office, so I email them the retainer agreement, eSign.com, and it's as simple as that. It just makes business happen. So, today we are working on an analysis of Alex Murdaugh. I keep saying Alec. But Alex Murdaugh, now let's just kind of recap some of the things that have, see, we all know what we're talking about. Alex Murdaugh is charged with 2 murders, murder of his son and his wife, Paul and Maggie Murdaugh. Now, it's interesting to note, though, since 2015, there have been 5 deaths associated with this family. Mallory, who died in a boat accident where the boat was driven by Paul, and actually Paul was scheduled to go to trial shortly around this time when this happened. Then you've got Maggie and Paul, those 2 deaths. Then you've also got the death of the housekeeper, and then you've got the death of this young man who is supposedly in some kind of relationship with Buster. So, and he was found in very suspicious circumstances. So it's really got a lot of intrigue into this whole family. You've got Alex Murdaugh, who is 4th generation for this law firm. They've got all kinds of financial problems. And he's got an estate. And he's lying. He's a lying liar, right? So let's talk about some of the mechanics of the night in question. So we know that he lied. And by he, I mean Alex Murdaugh. He lied about being near the kennels. And why did he told the cops he was never there. He changes his story when the evidence comes in that the snap has his voice on it. Now, Buster testified that wasn't my dad's voice. But now Alex Murdaugh was testifying, yeah, that's my voice, and I was there. So you lose credibility with the jury when you lie, period. Now, let's talk a little bit about having your client testify. It is a dicey situation. 2 things. 1, you really like to keep your client off the stand if you can at all avoid it. If you can avoid having your client testify, you don't want them because they're not professional witnesses. And even if you're a lawyer, you're not a professional witness. You don't know what tricks are up the prosecutor's sleeve. Number 2, if you are going to testify, you want the testimony that they give to be the first time anybody hears anything out of their mouth, as opposed to all the statements that Alex Murdaugh made to the cops prior to, getting arrested. So, when you have a he said, she said case, like let's say it's a crim sex case or an assault case of some kind, sometimes you have to have your client testify because if you don't have your client testify, they only hear one narrative. And if they only hear one narrative, you're going to lose. But when you have a case like this, where there is no forensic evidence really tying Alex Murdaugh to the it's all circumstantial. We'll talk about that in a second too. Is it a smart idea to have him testify when the whole testimony, the whole cross-examination is going to be one long character assassination? He's got so much baggage. He's got theft of his law firm's money, theft from a buddy, theft of client funds, theft of a wrongful death settlement from his housekeeper. I mean, it just goes on. And then he lies. So here's just a few lies. He lied about being at the kennel. And he lied to the detectives about that. He lied about when the last time he saw, said the last time he saw them was at dinner, which wasn't true because he was at the kennels. He lied again about not being at the kennels. He blames the lies on his addiction and because of my addiction, you look at all this circumstances, I get paranoid. And think about it this way. You can ruin a marriage on one lie. And there's a doctrine in law called falsus in uno, falso in omnibus. You can have, and which essentially means if you're lying about one thing, you're lying about everything. And it stands for the proposition that if you don't believe him on one thing, that you can disregard his entire testimony. That is a doctrine that I argue all the time, especially if I can prove that the other person, the witness, was lying. In this instance, it is a totally circumstantial case. What does that mean? That means you have to look at the big picture because there's no video, there's no forensics, and you have to try to put the puzzles together and infer from the evidence that is there. So one of the things that the prosecutor will argue is that these lies demonstrate a consciousness of guilt. A consciousness of guilt is a powerful tool for the prosecution. Now, I know a lot of people are on the fence, but one of the things that the prosecution is going to argue is that use your common sense, people. There is no other alternative. There's no evidence of anybody else being on that property. And there's evidence that Paul is there. He puts himself there right around the times of the murder. So it's right around 8:50 p.m., right? And around that time is the last time that Maggie's phone and Paul's phone are locked and no more activity on their phone. Now, there's some other information about, Maggie's phone being outside the gate of the compound. And let me just tell you the difference between cross-examination and direct. Direct examination is where the proponent of the witness or whoever is calling the witness asks certain questions, okay? And they ask them in a way that has to be open-ended. Cross-examination infers the answer is in the question. In other words, it was cold out yesterday, wasn't it? And, as opposed to, what did it feel like yesterday? So that's kind of the difference between cross and very simplistic, of course, but cross. And so the prosecution can cross-examine him and it's like, isn't it true that you lied? And when you lied about a material fact. And you lied to deputies. And you lied to deputies about your son and wife's murder. And in fact, you lied about where you were that day. And when you lied about where you were, you knew full well that you were right there at the scene, and you lied about being at the scene of the crime. Isn't that true? That's kind of the tenor of what a prosecution does.
Many times in the past.
Mr. Murdaugh, are you a family annihilator?
Now, that should be objected to as argumentative. So, that's the other thing. When you ask questions, you can't just ask whatever you want. I mean, you can't just be abusive to the witness.
Annihilator? You mean like, did I shoot my wife and my son?
Yes.
No. Would never hurt Maggie Murdaugh. I would never hurt Paul Murdaugh under any circumstances.
Say that.
So, you watch him walk, in the well of the courtroom, and typically, that's not how it's done. In federal court, there's a podium that's right in the middle, and you have to have either a hand on it or you have to be right behind the podium. You can't walk around like this.
Excuse me?
Say that, but you lied to Maggie, didn't you?
I did lie to Maggie.
You lied to Paul?
Sometimes.
You lied to your father?
So when somebody's on the stand, one of the first thing you do, one of your main missions is, if they're, you're an opposing witness, is to destroy their credibility. And that's what the prosecution, you're a liar, you're a liar, you're a liar, you're a liar. And he does this over and over again.
I'm sure I did at some point.
Did you tell him all the stuff you'd been up to over the years before he died?
No, I didn't tell him.
Did you lie to your brothers?
About financial things?
Yes.
This is actually one of the ways you get on snitches. You talked about all the different people. This is a classic cross-examination of a snitch, in a sense, because you got to destroy their credibility, and how you do that, by painting them as the liar that they are.
I would have lied to Randy at some point, I'm sure.
Did you lie to him about the last time you saw your wife and son alive?
I did.
Did you lie to their wives?
I'm sure I did.
Did you lie to Marion Proctor?
Yes.
And as you're sitting there as a defense lawyer, this shit sucks because it's like a boxer who can't punch back.
Bart Proctor?
Yes.
Did you lie to the Brandstetters?
Yes.
Did you lie to your best friend, Chris Wilson?
Probably.
Did you lie to your other friend, Barrett Bulware, when you took his money?
No, sir.
No.
I didn't lie like I told you. I didn't lie directly to him. I lied to him by omission, like we talked about. I mean, I didn't talk to him. I didn't see him at that time.
Did you lie to your law partners?
I did.
Did you lie to him about the kennels?
Some of them.
Did you lie to Mark Ball?
Yeah, based on what Mark said, I believe I did.
Did you lie to Ronnie Crosby?
According to what he said, I believe I did.
Did you lie to Johnny Parker?
I don't believe I ever discussed that with Johnny.
Did you lie to him about the finances when you borrowed that money in July of 2021?
I don't know if I lied to him about. I don't think Johnny asked me. I don't think I had to lie to Johnny about that, so I don't know.
Did you lie? Well, you certainly didn't disclose to him the truth when you borrowed that $250,000, did you?
I did not tell him what I was going to use it for.
I mean, didn't we say before that not telling the whole truth is the same as telling a lie?
Sure it is.
You don't think that's a lie, though?
I'm just saying, Mr. Waters, I'm not taking issue with that, but I don't even know that Johnny and I mean, Johnny had loaned me money numerous times. It wasn't any long sit-down discussion where Johnny wanted to know exactly what I was doing with it. That conversation would have been, I needed it. Johnny was always willing to help me, and that would have been the conversation. So on that specific event, did I lie to him? I don't know.
He ended up being out $477,000, didn't he?
He ended up being out a lot of money.
When you have somebody not only that are lying to people, but also financially abusing all those around him, including his own law partners, his brothers, and his clients, and everybody around him. The guy is swimming in debt and swimming in losing his lifestyle. And I'm not really buying the whole opiate addiction that is $50,000 a month. I mean, that'd be $600,000 a year. I'm not. I mean, certainly that may be part of it, but in 2019 alone, he stole $3.7 million from his law partners. So that doesn't account for just the addiction part of it.
And thank you for your qualifications as to that. Did you lie to Lee Cope?
I don't know. I don't know if Lee Cope was around when I said that or not.
Did you lie to Danny Henderson?
I did lie to Danny.
Did you lie to Jeannie Seconder?
About finances, yes, I did.
You didn't ever talk to her about the kennels?
No, I wouldn't think so.
Did you lie to Annette Griswold?
I did.
Did you lie to Christy Gerald?
So we're in the 5th week of trial, right? And so there's been over 70 witnesses. So this is a big trial. And it's grueling, especially when you have this many people testifying. And so now you have Alex on the stand. And and he's going to keep this all together. But he's had the benefit of a 5-week trial. He knows what the evidence is. And he's already given a prior statement. So he's going to shift and dodge and duck and weave.
Your other secretary, the paralegal.
I don't believe she and I discussed. I would have at some point, I'm sure.
Did you lie to Michael Gunn?
I'm sure I did at some point, but I mean, Michael wasn't involved in any of this, so I don't know that any of this ever came up with Michael.
Did you lie to your clients? Did you lie to Pamela Pinckney?
I did.
Natasha Thomas?
I don't know that I dealt with Natasha, but I certainly lied about that. Again, I don't know that I talked to Hakeem, but I certainly lied about that.
You know why people lie, Mr. Murdaugh? Because they know they've done something wrong.
For the most time, I do.
You've been able to lie quickly and easily and convincingly if you think it'll save your skin for well over a decade. Isn't that true?
That's pretty powerful. You know why people lie? Of course you do. And you've been doing this for 10 years to save your hind end, you know?
I have lied well over a decade.
And you want this jury to believe a story manufactured to fit the evidence that you brought forth just yesterday after hearing this trial's worth of testimony.
No, sir, that's not correct.
Mr. Murdaugh, we went through this for a while, but you remember at the beginning of your testimony, I asked you whether or not you agreed that trying to explain your presence on the kennel video was the most important part of your testimony before this jury. Remember?
One of the things that they also try to do is, whether it's with any witness, try to get them to agree to as much of your theory of the case as possible. So things that, you know, you can't argue with, things that you cannot dispute. And then when he changes his story, watch what happens.
And you said, oh, not the most important. I said, was it at least important? You recall that from yesterday.
Yeah, I recall you asking those questions, yes, sir.
And you agree it's important, don't you?
I agree that is an important component. But I think there's a lot of important components.
And you testified yesterday, and during cross yesterday and cross today. It's kind of evolved on the fact of the factors that led you to decide to lie at some point during that interview with David Owen, correct?
I disagree with that. I don't think those factors have evolved. I mean, you've asked some more specific questions, but those factors are still the same factors. You may have asked questions and gained a little more detail, but those factors haven't changed.
But it was the dope paranoia. It was the fact that the deputy took your GSR. It was the fact that your law partners and Greg Alexander and the sheriff were telling you needed to have a lawyer before you talked to police. It was a factor that you got in the car with Dave Owen and thought.
GSR, by the way, is gunshot residue. It's a test they use to determine whether or not you've fired a weapon.
Somebody else from some case 10 years ago, correct?
That believing David Owens was the person involved in the case that I talked about was one of the factors that caused me to distrust SLED.
All right. And then also you said that they started
And SLED, just so you know, is South Carolina Law Enforcement Division.
asking you about, in that first interview, about your relationship with Maggie and Paula. And that's one thing you mentioned as well, correct?
And that was certainly something that contributed to me having paranoid thinking.
And when you watch his body language, you know, he's a sniveling, and I don't want to say sniveling. He's crying, he's weak, and it's hard to determine what's genuine and what isn't. especially with somebody who's used to lying. But the one thing that I keep coming back to is I don't really get the motive here. You know, he's got all this shit coming down on him like a ton of bricks, and he wants to get sympathy for his death of his wife and his son, so he's gonna kill them to get sympathy. I'm just not. I mean, to kill your own kid to distract from the problems that you have, I'm having a little hard time with that motive. My understanding is that Maggie may have hired a forensic accountant to look into their finances, but still, to go to the length of murdering your wife and son, when, if he did it, certainly wasn't well thought out.
Yes, sir. That's what it looks like.
Okay. The police are here now. The police are here now.
But so just like I'm having trouble wrapping my head around the motive, I'm also having trouble wrapping my head around the fact that there's no evidence of any other intruder, no evidence of that, footprints, no tire tracks, no evidence that anybody else was on that property, and he's the last one. And it's undisputed that he's the last one to see them alive. Sometimes the lack of an alternative can lead you to the conclusion, that is like the only conclusion. He's the last one there. He had to have done it because there's nobody else that could have done it.
When was the last time you were here with them? Or talked to them or anything like that?
When was the last time you were here with them or talked to them or anything like that? Listen to what he says. Now keep in mind, if he did it, it happened probably an hour and a half ago, and he's had this time to kind of build up, figure out what the hell he's going to say.
It was earlier tonight. I don't know the exact time, but
Okay.
I left. I was probably gone an hour and a half from my mom's, and I saw them about 45 minutes before that.
So, and we know that's not true because he's on that video. You can hear him on the kennel snap video that Paul took, and that is right around 8:50.
That was Sergeant Green, correct?
Yeah, that was Sergeant Green.
And at that point in time, Sled was not there. No one had gotten GSR from you. Your law partners or Sheriff Hill were not there.
That's correct.
No one had asked you about your relationships. David Owen was not there.
That's correct.
But you still told the same lie. And all those reasons that you just gave this jury about the most important part of your testimony was a lie too.
So this is a common trial technique, where a prosecutor starts out calm, and then build. Now I'm pissed off because you lied to this jury, and that's exactly what he's doing. But he does make a good point. All the things that you said were the reasons for lying didn't exist at that particular moment.
Isn't that true, Mr. Murdaugh?
I disagree with that.
Nothing further.
Here's how this works. So his own lawyers put him on the stand first, right? And then question them. And then the prosecutor asks questions. And then if you can go back and clean things up a little bit by allowing him to explain certain things with what they call redirect. But your redirect has to be limited to what the cross-examination was, okay? And then if there's recross has to be limited to what the direct examination. So it just narrows the issues down over and over again.
States 569, and You recognize the person on the right in that image?
No, sir.
You don't recognize that?
I don't recognize him.
No, I'm asking about that.
Me?
Is that you?
Yeah, it looks like me.
All right. What's hanging out of your pocket in plain view?
Looks like a badge.
You didn't recall that until I just showed you that picture?
No, sir, I did not.
Your Honor, it also states 569 in the evidence. That's you in the white shirt, is that right?
Yes, sir, it is.
And this is the badge hanging out of your pocket? Remember which, is that correct?
Looks to be, yes, sir.
Which badge is that? Which one of the two? Remember?
Nah, you can't tell from here.
Okay. Why'd you have it hanging out of your pocket like that?
I don't remember having that. I don't know.
You don't remember that?
I don't remember that, no, sir.
Did you generally walk around with your badge hanging out of your pocket?
Generally speaking, no, sir, I did not.
Or only when you wanted some advantage from it?
Did I?
Did you want some?
My understanding is that they had a prosecution contract, and that's where the badge comes from.
Advantage from wearing it like that?
Did I hang it out my pocket when I wanted an advantage?
Yes.
I may have.
Okay.
I certainly may have.
What advantage did you want
When?
then?
I don't even recall this, Mr. Waters, but if I was wanting some advantage, as you say it, I guess I was begging for a meeting with y'all to try to bring this to a close, to talk to y'all about everything up until the time that y'all charged me with hurting Maggie and Paul. Now,
So what he's talking about there is this boat accident where Paul was driving drunk and killed one of his buddy's girlfriends. It's Mallory Beach.
I stopped, obviously.
Claiming that you were begging for a meeting and but you admit information was never conveyed that you wanted to change your story after multiple interviews with law enforcement about what happened that night, including the most important fact of all, which is when the last time you supposedly saw your wife and son alive was.
That is probably the most salient and important fact in this case. When did you last see, who was the last person to see them alive? That would have been Alex Murdaugh. And he lied about that particular fact. That is super damaging.
I don't know exactly what was conveyed or not to you because I wasn't part of it. All I know
Fair
is
enough.
what
You don't
I was trying to do was to sit down. I understood to bring all this to a close that y'all would want me to sit down and go through all of these financial things, all of these things that I'd done wrong.
Here's the thing. Even if he's acquitted of this, I mean, he's guilty of stealing about $9 million over the course of several years. And he's admitted to every element of those offenses. So regardless if he goes to prison on this or not, he's definitely going to prison on the financial crimes.
And to try to bring that to a close, I was repeatedly trying to sit down with y'all.
The reality is, Mr. Murdaugh, is the reason why no one's ever heard that before is because you had to sit in this courtroom and hear your family and your friends, one after the other, come in and testify that you were on that kennel video. So you, like you've done so many times over the course of your life, had to back up and make a new story that kind of fit with the facts that can't be denied. Isn't that true, sir?
No, sir, that's not true.
And so the answer to that question really doesn't even matter. And the reason it doesn't matter is because the implication is out there. So the jury hears what, the argument basically that's being made by the prosecution.
You've done that over and over again over the years with all of this that we've been talking about, haven't you?
I've done what over and over again?
The second that you're confronted with facts that you can't deny, you immediately come up with a new lie. Isn't that correct?
Mr. Waters, have we established I have lied many times, but I can't sit here and tell you that, what are you talking about, facts that I can't deny? That I would disagree with that proposition that you're putting out, that was what I did all the time. But in doing that, I admit again that I've lied to people that trusted me.
So we can agree that the prosecution and law enforcement and so many of your friends and family heard for the first time your story about the kennels yesterday after all these weeks of testimony. Can we agree on that?
That law enforcement, my partners, and my friends heard me say that for the first time. Yes, I agree with that.
And that's powerful. So he's getting him to agree that you're lying and lying and lying. But he's not getting him to agree to the ultimate facts because he disputes the facts. But the fact that he is lying and has been able to sit through this whole trial and now comes up with different stories in order to save his ass, the jury can use that for any purpose. When somebody lies, there's a limited, you can use it to judge their credibility. Well, they can use it to determine whether he's guilty or not. If they believe that he's lying to save his ass, the jury can use that to determine whether or not he's guilty. Is this consciousness of guilt? So what we've seen here is we've seen just an absolute character assassination. And it matters and it doesn't matter. It matters in the sense that, you can't trust a word this guy says. I mean, would you, and one of the instructions to the jury is what proof beyond a reasonable doubt is. And it's the proof that one would use in their most important of affairs. And so when you talk about, and as a prosecutor, the prosecutor can use that and say, would you rely on Alex Murdaugh's word in your most important affairs? I would tell you that his word is worth zero. And there are some unassailable facts in this case. He lied. He lied about being the last person to basically see them alive. And he lied about his whereabouts, where he was on the property. And it's not until he testifies that this comes out. So I don't know what's going to happen here. I don't know what a South Carolina jury is going to really want in terms of proof. Very rarely do you have a situation where you have the homicide happening on video. I've had that happen on multiple occasions. But this is at a large property, and it'll be really interesting to see because you're going to get a verdict next week. But I'm left with two questions. One, wish there was more forensic evidence, right? Something more to tie him to this. And then the other question, if it wasn't him, then who? And there's no evidence of the other who. He makes this bald assertion that his son was in this boat accident and he's been threatened over and over again. And then he even made the comment that he reported it, but there's no report. And he backtracked on that. So even that part of the story is not solid for him. So every part of his testimony, I think, is suspect. And when you have such a flawed individual, the idea that his lawyers wanted him to testify is probably ridiculous. Because his lawyers wouldn't... Because if he doesn't testify, a lot of this shit doesn't come in. It's certainly not to the length that it's come in through him. So... And all these lies and everything it really displays a very, very poor character. So this has just been our reaction to Alex Murdaugh's testimony. There's a lot more testimony we could have reacted to, but there's just so much of it. We'll probably maybe do another reaction next week when we get the verdict, and if there's any other breaking developments, we'll bring it to you. Thank you for watching us. Thank you for subscribing. Follow us on Instagram. Follow us on Twitter. Sign up for Patreon. And we'll see you next time here on Criminal Lawyer. This is Bruce Rivers. Welcome to another episode of Criminal Lawyer Reacts. CLR Bruce Rivers. I am Bruce Rivers, board-certified criminal defense lawyer, where I actually don't do just this. I love doing this. But I actually go across the street to the courthouse and try cases. Now, today we are reacting to post-verdict shenanigans by the Amber Heard team. Now, notice there was just one brief statement from the Johnny Depp team, just thanking everybody, and and it was very short, very sweet, and that's it. You haven't seen them make the rounds on the talk show circuit. They may or may not, but I think here's the problem that Amber Heard's team has. They're going forward and making statements that she's a domestic abuse victim, and they don't have a verdict to support that. But let's kind of watch what Elaine had to say, and then I'll react to it on the other side of it.
A Virginia jury's decision to side with Johnny Depp in his defamation lawsuit is drawing both condemnation and praise. The verdict came after 6 weeks of very dramatic testimony from both sides. She claimed that he abused her, while he said she was the abuser. In his reaction, Depp wrote, "The goal of bringing the case was to reveal the truth, and that truth never perishes."
I've had a lot of people, not a lot of people, but some people talk about this notion that this has set the women's movement back, or the Me Too movement back. The light of day is not going to put any movement back. Facts are what rule the day. And if a woman is to be believed, which they should be believed, but it should withstand scrutiny, and the facts got in the way of Amber Heard.
Elaine Charlson Bredehoff is the attorney for Amber Heard and is with us now. And we should mention, we did also reach out to Johnny Depp's team, but they declined to be interviewed this morning. Elaine, thank you. We're so very glad you're here.
Thank you.
We heard Amber's reaction to the verdict yesterday. This seems to be a huge victory for Johnny Depp this morning.
Yeah, a major setback for women, for women
Bullshit.
inside the courtroom and outside the courtroom.
Because?
Because basically what this said, Amber had an enormous amount of evidence, although a lot of it was suppressed in this case as opposed to the UK. But look at all the women who have no evidence.
So Amber Heard had a lot of evidence. She didn't have any photographs of any injuries. And there were several rebuttal witnesses who completely contradicted her. And in fact, she didn't have really hardly any witnesses that corroborated her to a degree that she was discredited on rebuttal.
All these women who suffer from domestic violence, domestic abuse, they don't have evidence. And basically what this jury said is, unless you pull out your cell phone and you tape record your spouse beating you.
That isn't what they said. There were so many things that were absolutely provably false. And I think that's, remember what I said a while back? Falso in uno, falso in omnibus. If you're lying about one thing, you're lying about everything. That's the credibility of a witness.
You're out of luck.
But Elaine, I think it was bigger than that, because you had the evidence, as you say, but they did not believe her. Why do you think they did not believe her?
I think that a lot of that was that it was Johnny Depp.
Not the facts of the case. No. It couldn't be that they shoved a bunch of rebuttal witnesses up her ass and completely contradicted her with facts. It has nothing to do with Johnny Depp. Why weren't there, she goes to the courthouse with a bruise on her face, supposedly, 6 days after she had seen him with no makeup on. And she didn't set that up. She set that.
I think the celebrity status.
But she's a celebrity too.
And it's not only not
she's
believing her.
but she's a celebrity too.
Right.
Here's the problem. You're on this losing side. To be honest with you, nothing can be gained by her making this appearance on TV, honestly. I think it was smart for the Depp team to decline and not be public about this. I'm sure Johnny Depp says, I don't want this. I don't want you to trash her. I don't want you to say anything about her. And now you've got Elaine kind of going ham on Johnny Depp.
But you have to remember, it's a tale of two trials. All the evidence came in the UK. Mr. Depp brought that one. The burden of proof was on the Sun in the UK, because they had called him a wife beater and talked about the domestic violence.
See, in the UK, Amber Heard wasn't a defendant. So it just was, it's not really analogous at all.
He had his opportunity to tell the truth then. And a 3-week trial, he lost. The judge found 12 acts of domestic violence, including sexual violence. And that came out November 2, 2020. We weren't allowed to tell the jury that.
Well, it's a different system, and the judge, it wasn't a jury, it was a judge. The judge had a substantial...
And it's a completely different set of facts in terms of, you've got a different parties. And whatever that verdict over there was has no bearing on what the jury is going to consider in this case.
Really true, and that is significant, and I think surprised a lot of legal analysts. But in this case, the jury not only didn't believe Amber Heard, but in ruling that she acted with actual malice, that means she had the intent to cause harm, right? That's a pretty high standard to have proven.
And it's pretty amazing since the op-ed never even mentioned Mr. Depp. You have to remember that. What they learned from the UK case.
The op-ed never even mentioned Mr. Depp. But didn't Amber Heard, in her testimony, she said it was about him. And then the jury believed her when she said that.
Is to demonize Amber, which is what they did, and to try to suppress as much of the evidence that came in the UK and did not come in the United States. But the other problem is we had cameras in the courtroom. So here we had, not only did...
It's everybody's fault but mine.
We have a group of Depp fans that were there every day. 100 were allowed in. They lined up at 1 o'clock in the morning for their wristbands to be in that courtroom. But we had everything on camera, and we had tremendous social media that was very, very, very much against Amber.
It was pointed out that that was the first time that a victim of sexual abuse had to testify on live television.
And I fought hard and lost that battle. So it should not have happened.
Most laws about cameras in the courtroom, if one party wants them in, they come in.
So I am a former NFL player, and after a hard loss, it's easy to wake up and point to the other side. Oftentimes, I realized the better thing to do was to look in the mirror. What mistakes did I make as a player? What mistakes did our coaching staff make? And then how can we improve from there? Do you feel like you guys made any mistakes along the way? Do you feel like Amber made a mistake while she was on the stand? Because you're saying it's the celebrity, it's Johnny, it's the people who support him. But what about you and your team?
Now, that is an excellent point. And the thing about it is, it's really hard for somebody who charges about $6 million to defend Amber Heard to say they made a mistake. And you sit there, she's not going to self-snitch. I mean, that's just not what she's going to do.
Well, and that's an excellent question. And to say, and Amber even said on the stand, I am not perfect.
Okay, let's blame Amber.
I am a human being. These people were giving her death threats. They threatened to microwave her baby. This is the kind of social media she was getting.
So microwaving the baby is why you lost the case. That's something you did wrong?
So are any of us perfect? No. Is there something else we feel we should have done? Yes, absolutely. I redo my closings 100 times afterwards, whether I win or lose. That's part of being a good lawyer, a good trial lawyer is.
Right. Bullshit. I don't redo my closing 100 times. If you literally redid your closing 100 times, guess what? You're indecisive and you don't know what the fuck you're talking about. Pardon my French.
There's always something. But I think that there were a lot of influences here that were beyond our control. And I think the social media, it was like a Roman Colosseum. It is the best way to describe the atmosphere here. And I have to believe that the jury, even though they're told not to go and look at anything, they have weak.
So now it's the jury's fault for looking at social media. So, I mean, so it's the judge, it's Amber's imperfect, she's pointing any fingers back at herself? No.
Weekends, they have families, they have
they were not
media.
Sequestered. They were not sequestered.
And the 10-day period we had, how could they not have been influenced?
But Elaine, for most people watching this trial, and a lot of people, as you know, got huge views. It just seemed to be so messy and salacious and so tawdry on both sides. And I think for a lot of people from the outside looking in thought both of them were not telling the truth and that they mutually abused each other. Do you not believe that that was the case?
No, and that's one of the many misnomers. The way that Depp's team approached this was based on ignorance of domestic violence.
The way the Depp team approaches is to kick your ass.
it completely ignored the cycle of violence and just said, oh, she wouldn't have done this if he had been hitting her. That was their approach.
So you thought that they weren't fighting fair?
Correct. I don't think they were fighting fair.
And you think
Objection. 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 I'm trying here, Judge. I'm trying. I mean, what the hell?
Amber
Absolutely.
Heard is, in fact, a survivor of domestic violence?
Yes, I absolutely believe that, and there's a tremendous amount of evidence.
The problem is she could run into some defamation problems herself.
Much of which did not come into this trial, did come into the UK trial. We even had more evidence. We had medical records. We had mental health records that went back to 2012 that were contemporaneous. We had text messages from Mr. Depp's assistant saying, when I told him that he had kicked you, he cried.
So how
That
is she
didn't come
today,
in.
Elaine? How is she today? What
She's
is her
heartbroken.
next move?
She's right. Well, her next move is appeal. There were
But
a
she's
number.
heartbroken.
She is.
She ain't gonna appeal it. She's worth what? -8 million. She's donated $7 million synonymously with pledged to a couple charities, and now she owes 8.3. So she's worth the -8 million and net worth. And so is she gonna have to now put a bond up? She's gonna have to put a bond up for at least 10 million plus. That's the amount of the judgment plus attorney's fees.
Is heartbroken. And one of the first things that she said when she came back from the verdict, when we went into the conference room, was, I am so sorry to all these women.
She said that?
Yes. She felt like she had let down all of these women because she had.
Well, she did, because she used the fake domestic abuse to further her ends.
Had more evidence than most people do, and yet they still didn't believe her.
Elaine Charleston, Murdaugh, thank you so much for.
So that's her on the ABC morning show. Let's just take a glimpse. We're not going to play the whole thing, but let's see what happens with her on the Today Show.
Amber Heard's attorney, Elaine Charleston. Murdaugh, good morning to you. First question, how is Amber doing? We saw her hearing that verdict. It took a long time to read. It was a sweeping verdict for Johnny Depp. How did she handle it?
You know, one of the first things she said is, I am so
Gee, it sounds similar to what she just said. I mean, this is going to be word for word.
sorry to all those women out there. This is a setback for all women in and outside the courtroom. And she feels the burden of that.
Well, knowing the case and knowing the law, as you certainly do, it favors defendants like Amber Heard. Are you stunned
Good
that
point.
the jury essentially rejected her story?
Well, you know, really what happened here is it's a tale of two trials.
Sounds similar?
Johnny Depp brought a suit in the UK for the same case. And
It isn't the same case. It is not the same case. It was a case against a newspaper.
the burden of proof was easier for him there. The Sun had to actually prove that it was true, and the court found there, and we weren't allowed to tell the jury this, but the court found that Mr. Depp had committed at least 12 acts of domestic violence, including sexual violence.
Totally different process there. Totally different standard. And you only have one fact finder, and that is the judge in that case.
Against Amber. So what did Depp's team learn from this? Demonize Amber and suppress the evidence.
In other words, challenge the facts.
We had an enormous amount of evidence that was.
I'm not going to play the rest of it, but you get the gist. I don't think it's wise for Elaine to go on these shows. I mean, you're the losing side, and you're not taking any responsibility for losing, and everybody has a problem except for you. This is the jury's problem. It's the judge's problem. It's the Depp team. You got your ass kicked, and guess what you do when you get your ass kicked? Because I've gotten my ass kicked many times. You shut the fuck up and you just kind of move along your way, and you go on to the next case. I really doubt that Amber Heard is going to appeal this. So this has just been a little bit of Elaine, and one other issue came up. A TikToker is claiming to be a juror and said that most of the people in the on the jury wanted to give him the $50 million that he was asking for, 2 holdouts, and so they compromised. And that's what I thought all along. I thought they did prove their damages pretty well, but the $2 million for Amber and the $15 million for Johnny Depp, that seemed like a compromise verdict to me. And compromise is something that happens all the time with these verdicts. So this has been Criminal Lawyer Reacts, reacting to the post-trial shenanigans on the Johnny Depp versus Amber Heard case. So we'll see you next time. Make sure you subscribe, follow us on Instagram, follow us on Twitter, sign up for Patreon, and spread the word. Stop your self-snitching. Bruce Rivers, Criminal Lawyer Reacts. We'll see you next time. This is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer. Today's episode is brought to you by eForms.com. That's eForms.com. If you need a power of attorney, you need a loan agreement, you need any kind of form, eviction form, anything where you want to do some legal work on your own, go to eForms.com. They are amazing. Sometimes even a practitioner like me will go there so I don't have to reinvent the wheel. So go to eForms.com so you don't have to hire a guy like me. So we're reacting today to the news that Amber Heard has reassembled a team of lawyers. So if you remember in Amber Heard's trial, she was represented primarily by Rattenborn and Elaine, right? Well, she's ditched Elaine, and now she's got Rattenborn, and she's got J. Ward Brown and David L. Axelrod. That's her new appellate team. And if David Axelrod and Jay Brown are most famous for representing the New York Times when they were sued by Palin, and they successfully defended that suit. So, and basically, they're First Amendment guys, and I think that First Amendment is a little, Ben Rattenborn had argued about the First Amendment during the trial, if you remember. And it's interesting that Elaine is now out. Here's the thing. That often happens because what you have to do when you have an appeal is find what the errors were in the trial, okay? And so I guarantee you one of the things they're going to do on appeal is they're going to go after Elaine for ineffective assistance of counsel. I would be shocked if they didn't do that. There were so many times where she just threw her hands up and she just got her ass handed to her, if we remember. And so the other thing is the First Amendment issue, that that Amber Heard's activities were somehow protected by the First Amendment. I just don't see that happening, because if you remember what the First Amendment is the right to free speech, right? But you don't have the right to any free speech. If what you're saying is false and you're defaming somebody, you don't have the right to just say what you want to say whenever you want to say it. There are complications consequences for yelling fire in a crowded theater, for example, or if you defame somebody and they're actually hurt by your words. So it'll be interesting to see exactly what's going to happen with this appeal, but they have to do a couple things. They file a notice of appeal, which they've done. Then they get the transcript of the trial, and it's a 6-week trial, so that's going to be a lot of things to go through. And then not only do they have to do that, they have to assign some kind of fundamental error. And if you look at some of the post-verdict motions, we can kind of glean what they're going to do, because that juror issue will probably be an issue on appeal. The judge's rulings about keeping evidence out will be an issue on appeal. I guarantee you Elaine's performance will be under scrutiny. That'll be an issue for appeal. The First Amendment, I just don't see it. I just don't see that she's got a First Amendment issue. The First Amendment, really talks about government action. That's your constitutional rights are protected from government action. So, for example, the Fourth Amendment right against search and seizure, well, you don't have a Fourth Amendment right, against having your neighbor come in. It's really against the government coming in without a warrant, because your neighbor couldn't. That's just called burglary. That's just a totally different animal. But the First Amendment, you protect speech from an intrusion or a restriction by the government, not necessarily by another party. So the addition of these new lawyers to the team is, I think, a stroke of luck and maybe genius on Amber Heard's part. But who's paying her bill? I mean, honestly, if it's not being paid by insurance, which it probably isn't, who's paying her bill? Some other wealthy benefactor? Very, very possible. But I don't care how good her lawyers aren't going to be able to change the facts. And no matter what happens, they're limited to what happened during the trial and pre-trial, but just things that happen inside the courtroom. You can't raise anything new that hasn't been presented in the courtroom. I can't imagine, with all the things that was going on, that she's going to be able to come up with any kind of new evidence, because if it was available at the time, you're stuck. So I think it's going to be, the issues that I talked about, and it's going to be issues related to representation, because Elaine just didn't seem like she was up to the job, quite honestly. So now, as I said, your appeal is so different from what happens at trial. You have to, first of all, you're very limited in the time you get to argue. You only get like 15 minutes aside. Second of all, you have to have you got to present a brief, and that has to follow certain rules. When you look at what Amber Heard's lawyer, Elaine, what she did during the trial, none of that crap would fly at the Court of Appeals. And you don't have that much time. You can reserve a little bit for rebuttal, but you don't have that much time to argue your case. And in fact, the judges kind of have once they read the brief, they kind of have an idea of where they're going to how they're going to decide the case. And you can tell where they're going with your argument when they question you. Because here's what happens. You get up and you start arguing your case, right? And then they'll interrupt you. And you hope they interrupt you because you want to know what the judges are thinking. And it's a 3-judge panel. And so you sit there and you start your argument. And as you're starting to argue, counsel, isn't it true that Elaine was completely drunk during most of the trial? They wouldn't really say that, but that's what they do. They ask you, but isn't the First Amendment implicated? Or whatever. They'll bring something out that's in your brief or in opposing counsel's brief, and they'll ask you questions about it. Well, what about Sullivan versus New York Times? They'll ask you about case law. How is that different from this? And you don't really have that much time to argue. Arguing an appeal is really a completely different skill set. You have to have different writing skills. You got to have more poise, and you have to be differential to these judges, because if you have a adversarial tone with these judges or a non-respectful, you're going to be done. I mean, so it really is. You're in a high court, and you have to show the high court respect, just like you really should show the district court some respect. And I think when I was younger, I let things get to me more than I do now. And in fact, I love when opposing counsel goes off and I just sit there quietly and eat their lunch. That is just like a delicious dessert when that happens. Because it doesn't work with a jury, and it doesn't work with the judge. And all you're doing is maybe showing off for your client. And if it doesn't serve your client, don't fucking do it. So it'll be interesting to see where it goes. I think this judge was incredibly thorough. I think that both sides had all their opportunities. And here's the other thing. That like you have a presumption of innocence in a criminal case. Well, when you file your appeal and you make your motions and you make your arguments, they take your arguments in a light most favorable to the non-moving party. What does that mean? That means, given all things equal, they try to look at it and give every inference favorable to Johnny Depp on the appeal. So you don't get the benefit of any kind of presumptions on appeal, because the jury's verdict is going to be respected by the Court of Appeals, and the judge has broad discretion to make evidentiary rulings, and it's usually only where the judge has exceeded her authority and something so clearly erroneous. I just didn't see that happening and I watched quite a bit of that trial. The judge seemed like she was incredibly fair, that she took her time with rulings, gave everybody a chance to argue, and the judges have what they call an abundance of discretion. And the Court of Appeals is not going to, absent some kind of abuse of discretion, they're not going to disturb it. So we'll see what happens. This has been, our look at the recent developments of Amber Heard and her new team that she's assembled. So we'll see you next time here on Criminal Lawyer Reacts. I'm Bruce Rivers. Make sure you subscribe, like this video if you like it, and, stop yourself snitching. And we'll see you next time here on Criminal Lawyer React. But who better to know what the law is and the limits of the law than a lawyer? There's absolutely no justification for this. Put the thing away. He's not being threatened at all. Now, how do you defend that? The only way you defend that is if you say, "Hi, this is Bruce Rivers. Welcome to another episode of Criminal Lawyer Reacts. I'm Bruce Rivers, your board-certified criminal defense lawyer with our content genius, who has graciously gifted me these pearl-handle pistol cufflinks. Today, we're reacting to a retired lawyer/law professor who shot and killed a couple protesters in Panama. And this will be a good lesson in how not to use a firearm. But before we get to that, this episode is brought to you by esign.com. My grandmother's sitting downstairs in her basement, and guess what? She loves to conceal and carry. That girl just loves her Glock 9. Well, you know what? She's, not getting so mobile. And so what did she do? The people at the gun shop, she had to apply for a permit. So they downloaded the app. They got 3 free signatures a month. She was able to e-sign her concealed carry. And now grandma's packing a pistol. I use it all the time in my practice, all the time when I use it for a retainer agreement or I do any other kind of document that you need signed. So esign.com, a very effective way to remotely do business. You come across, you're in the road, and you're pissed off. You're pissed off because there's a bunch of protesters, whatever the protest. And in this case, they happen to be protesting. There were climate change activists protesting the opening of a copper mine. Just because you're pissed off does not give you the right to shoot somebody. It just doesn't. But there's a fine line between when a protest turns violent and you're able to use deadly force and when you're not. But let's take a look at this fine gentleman as he decides to trade the rest of his life for a moment of superiority. So you see people, with the flags. He's an upper end of society. He's a lawyer. He's a professor. Now, does that lady look like a threat to anybody with her glasses and her beads and her flag? No, she doesn't. And so you've got a line of cars. Is it inconvenient? Sure it is. Turn the fuck around and find another way around it. Now, he pulls out his firearm in this instance. Is there any justification for this whatsoever? He's doing this because, let's say for the sake of argument, somebody said, we're going to kill you. Well, then he would be. But I don't think that's what happened here. He's got no business pulling that firearm on, under any law, whether it's Panama or here. In order for it to be justified, 2 things have to happen. 1, you can't start the affray. And number 2, it has to be reasonable. You have to be in fear of death or great bodily harm. You think he's just pissed off because they're not moving. And why the hell would he continue to do this with all these news cameras? Because I guess there are all kinds of news cameras there, as you can see, because we're watching it. Now, anybody that would be stupid enough to challenge him, like grab the tire while he's got a gun in his hand, is somebody not playing with a full deck. Can't see, I guess he's not strong enough to pick up that rock. This is just sad, though, because 2 lives are lost here. Now, he's got this gun on, and actually brandishing a firearm and putting somebody in fear of great bodily harm is also an assault. You don't have to shoot somebody for it to be an assault. Assault is basically the apprehension of bodily harm, or the immediate apprehension of bodily harm. So if I go like this, that's a misdemeanor assault, as long as I put you in fear of, bodily harm. And when you have a weapon, That's still assault with a deadly weapon, whether you fire it or not. Put the thing away. He's not being threatened at all. He shoots 2 people. One dies immediately at the scene, and another one dies later at the hospital. Nobody's attacking him. There's absolutely no justification for this. Guess what? You're federally fucked now. I mean, his girlfriend, he tells his girlfriend to get in the car. You know what she says? We're not going anywhere. And she calls the police. That's what you call somebody who's true blue. And so he gets taken into custody. Now, how do you defend that? The only way you defend that is if you say some kind of a semblance that, they were threatening me. I wanted them to move, and I was moving their barricades so I could get through. And then they told me they were going to kill me. That's the only way you defend that case, whether it's true or not. That's his only defense. He has to be in fear of great bodily harm or death. So according to news reports, the roadblocks set up by the protesters have caused about $80 million in daily losses to businesses and other things. So, you had construction workers and teachers unions and all kinds of other people who have banded together to protest this copper mine. And this asshole's got to get out there, and he decides to shoot 2 people. So the 2 men that he shot were 2 teachers. Abdiel Diaz, who died at the scene, and Ivan Rodriguez, who was taken to a clinic but was pronounced dead upon arrival. Now, these are 2 teachers. I'll be honest with you, I'm not a big protest kind of guy, but it's your right to protest, right? Is it a pain in the ass sometimes? Sure is. But you know what? It doesn't mean that you have the right to kill. Now, this guy's a little bit older. He's 77 years old. So he's charged with 2 counts of aggravated homicide and illegal possession of a firearm. Now, I don't know if this is accurate or not, but according to one report, he could probably just serve house arrest because of his age. But he was ordered detained. One of the reasons we're showing you this is because this happens all the time with road rage incidents, and that's kind of this fits that kind of MO in a sense. You're really so pissed off that you have to act out. The more pissed off you get, walk away. Walk away and do whatever you can to de-escalate. Because when you're really pissed off, a lot of times you can either say or do something that you can't take back. It's like saying fuck you to your loved ones. You don't say that. You save that for somebody who's attacking your family, or something like that. You don't use it on your loved one when you're pissed off. Take a breather. This guy just ruined 2 families and his own family and himself. All for what? All because he was pissed off and he had a gun on him. Let's say he didn't have the gun on him. Nobody was threatening him that I could see. I mean, we don't know what they were saying because it was hard to hear, and I don't speak Spanish. I speak a little bit. But let's say he didn't have that gun on him. With all the cameras around, you think they're going to beat him to death? It certainly didn't look like it. These are a bunch of teachers. Could they have manhandled him a little bit? I suppose they could. But his anger did himself in. And who should know better? Who should know better? I mean, I'm all for guns. I'm all for home protection. I'm all for the Second Amendment. Absolutely. But I'm all for the Second Amendment. I'm all for the, ownership of guns for home protection and for, sport purposes and, hunting and hunting and that kind of thing. But who better to know what the law is and the limits of the law than a lawyer and professor, and that's going to go against him when he gets into court. But he was ordered remanded into custody. In other words, no bail for you. This is just a kind of an instructional video on what not to do. I really don't like concealed carry, because, and maybe it's just because I always see the wrong side of it, because people who come to me generally are people who have either fucked up or they're charged. And sometimes you can have a legitimate self-defense, but that's an affirmative defense, which means, they can charge you with the underlying crime, but you have to prove up, at least to a certain degree, self-defense. Once you get over that threshold, then you get to a jury, and the prosecutor has to prove that it was not in self-defense. Isn't that kind of weird? So they have to disprove a negative. Just be careful. And you know what? It's better to just go have a margarita and just enjoy your friends and family with a smile instead of this hostile BS. So we'll see you next time here on Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer. Our content genius, Michael Rivers, right behind the camera. And we'll see you next time. Make sure you subscribe, follow us on Instagram, follow us on Twitter. Hi, this is Bruce Rivers. Welcome to another episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer. Today we're reacting to Alex Jones as he mocks the jury when they awarded a large amount of money. But before we do that, remember this episode is brought to you by eForms.com. That's eForms.com. If you need a will, you need a power of attorney, you need a bill of sale, any kind of legal document, go to eForms.com. They can help you. And why pay a guy like me? Because I would just go to eForms.com, cut me out of this. Don't pay a lawyer a lot of money to create a form that you can do in 2 minutes. So go to eForms.com, find the link below. And now today we are reacting to Alex Jones. Now Alex Jones, he's been around the country defending himself against these horrible statements that he has made on InfoWars. He is so awful. He's made his money off of conspiracy theories, and that's where he's going to stay, right? So let's just get into it.
To plaintiff Robbie Parker. A, defamation/slander damages past and future, $60 million.
$60 million. Now look at him to the right here. He is in his studio. He's not in the courtroom, obviously. Yeah! Fucking yeah! Fuck you, man.
Emotional distress damages, past and future.
He is so disrespectful, and he's using this to make money. I mean, he's broadcasting this.
$60 million. Total fair, just, and reasonable damages to plaintiff Robert Parker and against Alex Jones and Free Speech Systems and Line A and Line B. Total $120 million. Yeah. Initialed by juror number 1.
Yeah. I don't know what he gets out of this except for just to be able to show that he's defiant. These families have gone through just an absolute horrible experience, and he's compounded that by just being so cruel, and then to react this way to the verdict.
To plaintiff David Wheeler. A, defamation/slander damages, past and future, $25 million. B, emotional distress damages, past and future, $30 million. Yeah! Total fair, just, and reasonable damages to plaintiff David Wheeler and against Alex Jones and Free Speech Systems and Line A and Line B, $55 million. Yeah! Initials.
Never said their name, don't know who they are.
To plaintiff.
The problem he's got is that he didn't defend the lawsuit, and he defaulted on most of these lawsuits, and then just defended it on damages.
Francine Wheeler. A, defamation/slander damages, past and future, $24 million. Yeah. B, emotional.
I don't know why he's doing this. It's just a shtick. It's just absolute shtick.
Distress damages, past and future, $30 million. Yeah. Total fair, just, and reasonable damages to plaintiff Francine Wheeler and against Alex Jones and Free Speech Systems and Line A and Line B, total $54 million.
Yeah. Now keep in mind, this is on top of the $50 million that he was already ordered to pay in another case. So there's going to be, get in line. He's not going to have this money. But he can't discharge this in bankruptcy. Why can't he? Because it's an intentional tort. You cannot discharge this in bankruptcy.
By juror number 1. To plaintiff Jacqueline Barden. A, defamation/slander damages, past and future, $10 million. B, emotional distress damages, past and future, $18,800,000.
Good.
Total fair, just, and reasonable damages to plaintiff Jacqueline Barden and against Alex Jones and Free Speech Systems at line A and line B, $28,800,000. Initialed by.
I don't understand the lack of humanity, but I mean just decency.
Get those numbers up.
To plaintiff Mark Barden.
The reason he's saying that is because he thinks he's completely insulated.
Come on, go. More than that.
In future, $25 million.
That's better.
B, emotional distress damages, past and future, $32,600,000.
Never said their names, all made up.
And here's the thing, it doesn't matter that he said their names or not. He said the whole thing was a hoax. And he went on and on and on and on. And he actually said in trial that he realized that it was real.
Nope. Hilarious.
Mark Barden
Is it hilarious? It ain't gonna be hilarious when they keep chasing his ass all over the country.
$57,600,000.
Good, that's better.
Initialed by juror number 1.
Get those numbers up.
To plaintiff Nicole Hockley. A, defamation /
And here's the thing. These antics here can certainly be used in any future proceedings against Alex Jones.
Slander damages, past and future, $32 million. B, emotional distress.
So the $73 million from Remington wasn't enough. This is quite a money maker.
$41,600,000. Total fair, just, and
the difference is Remington had money, we don't.
Hockley,
oh yeah, they have money.
and against Alex Jones at Free Speech Systems at line A and line B, $73,600,000.
Yeah.
Initial by plaintiff,
Get those numbers up.
See, now one of the things he's going to talk about later is about any kind of appeal, because he has the right to appeal these damage awards. But the problem that he's going to have is one of the things you have to say is that they're excessive. He's belying the point that they're excessive.
To plaintiff Ian Hockley.
And they're not down there to keep suing everybody. This is
slander
right.
damages, past and future, $38 million.
Good.
B, emotional distress damages, past and future, $43,600,000.
Good.
Total fair.
If we don't hit $1 billion, I'm not happy. I want to be the $1 billion man.
And against Alex Jones and Free Speech.
And it just breaks my heart that he's so callous.
Systems at line A and line B, $81,600,000, initialed by juror number 1.
Good.
To plaintiff Jennifer Hensel. A, defamation / slander damages, past and future, $21 million. B, emotional distress damages.
They actually believe they're getting this money. It's like they believe all their own stuff.
Total fair, just,
and here's the thing. They probably won't get any of their money. But they'll do the same thing that the Goldman family has been able to do to OJ. And that is, you chase him around here and there, and they can make his life hell. And he'll try to do the shell game with companies, with this and that, but they'll be able to make his life hell as time goes on.
Just and reasonable damages to plaintiff Jennifer Hensel and against Alex Jones and Free Speech Systems at line A and line B, $52 million. Initialed by juror number 1.
Bravo.
To plaintiff Donna Soto.
What a political joke. What a weaponized system. Because all they want is some $1 billion number. This is ridiculous. I don't have $2 million.
What's ridiculous is the fact that he is making another mockery out of these families.
Emotional distress damages, past and future, $30 million. Total fair, just, and reasonable damages to plaintiff Donna Soto and against Alex Jones and Free Speech Systems at line A and line B, $48 million. Initialed by juror number 1.
They haven't gotten to the FBI agent. I never said his name. Didn't know who he was. I want to hear that one.
Defamation / slander damages, past and future, $30 million. The emotional distress damages, past and future, $36 million. Total.
Very difficult to defend the damages amount when you don't even defend the underlying case.
Fair, just, and reasonable damages to plaintiff Carly Soto Parisi.
Well, this is going to go on for hours. If I don't hit $1 billion, I'm upset. And now they say, questioning elections, same thing. Got to sue Alex Jones.
To plaintiff Carlos Matthew Soto.
Can't get blood out of a stone.
Slander damages.
Oh, you got money.
Past and future, $18,600,000.
So this is what a show trial looks like. I mean, this is the left completely out of control.
But is it the left, really? No, it's not the left. It is people that you've hurt who are going after you. It has nothing to do with left or right.
Do whatever they want, like drag queen story time, two men can have a baby. I mean, this is what they do. This is their panacea.
At line A and line B, $57,600,000.
57 million, 20 million, 50 million, 80 million, 100 million, blah, blah. You get $1 million, you get 100 million, you get 50 million.
Slander damages, past and future.
Couldn't put on evidence, couldn't defend ourselves.
Emotional distress damages, past and
That's because he defaulted. He defaulted. And then his lawyers somehow gave the other side his cell phone information, a whole dump of his cell phone.
future $1 million. Total fair, just, and reasonable damages to plaintiff Francine Wheeler and against Alex.
Oh, I'm sorry. See, there's more charges. Oh, we're going to get to way past $1 billion. Oh, sorry.
$54 million, initialed by juror number 1. To plaintiff Jacqueline Barden, A, defamation/slander damages, past and future, $10 million. B, emotional distress damages, past and future, $18,800,000.
These are big numbers.
Damages
They covered up what really happened, and now I'm the devil.
against Alex Jones.
I'm actually proud to be under this level of attack.
At line A and line B.
He's saying that, but that ain't the facts.
Juror number 1.
Told you there's 4 charges.
Plaintiff Mark Barden, A, defamation/.
But remember, all of it's cap but cuppa, which they claimed I had some unfair business trade. The judge decides that. That's where it doesn't matter.
$32,600,000. At line A and line B.
Why are these numbers only in the millions? It should be trillions per person.
So when they go to make their motion for why these damages are too high, you got his own words saying that they're not high enough.
I'm offended.
To plaintiff Nicole Hockley, A, defamation/slander damages, past and future.
That's what the hell's like. They just read out your damages. Even though you don't have the money, you're just still got to sit there while they do this.
$100,000. Total fair, just, and reasonable damages to plaintiff Nicole Hockley and against Alex.
And they lie and say I made money off of them. It's a gun control lobby made money off of it.
$73,600,000, initialed by juror number 1. To plaintiff Ian Hockley, A, defamation.
Do these people actually think they're getting any money?
Past and future, $38 million.
And here's the thing, it doesn't really matter that they get any money or not. First of all, like I said, it's not dischargeable in bankruptcy. Second of all, if he wants to appeal and stay the execution of the judgment, he has to put up a bond for $965 million, which I don't think he'll be able to put up. And
B, emotional distress damages, past and future, $43,600,000. Total fair, just, and reasonable damages to plaintiff Ian Hockley and against Alex Jones and Free Speech Systems at line A and line B, $81,600,000.
$81 million. These are big numbers.
$81 million, that's good.
Plaintiff
We're well past $1 billion now, right?
A, defamation.
What are we at now, guys?
Damages, past and future, $21 million. B, emotional distress damages, past.
We've lost count. It's in the billions, okay?
So he does talk later about being able to just drag this out through the Court of Appeals and blah, blah, blah. Meanwhile, he'll do a shell game with companies and that kind of thing. So if you have, and during part of this, he was pimping his supporters to buy his supplements and powder, whatever the fuck he sells. But the problem that he has is that he's not going to be able to afford to put up a $965 million bond because you lose your appeal, they get executed on the bond. So that's number 1. Number 2, you can't discharge it in bankruptcy. And number 3, so these guys and the other plaintiffs can just hound him till his dying day and garnish bank accounts, garnish, whatever they can get their hands on, and just be a pain in his ass every step of the way. That's probably more likely what's going to happen. So he sits there and tells them, oh, you can't get any money from me. Any money he decides to squirrel away, they'll be able to find it. I mean, and when I say you can execute on assets, they could execute on his studio equipment. They could execute on his yacht if he had one. Probably can't take his house, but they can take just about everything else. So what I would do if I'm the plaintiff's lawyer, that I would want to take his studio equipment and shut down his business, because that I just can't believe he is just so lacking in decency and humanity. These families have suffered enough. Just fucking stop. But he won't, because that's his shtick. The election fraud, everything, whatever he does, it's all, the lizard people and whatever the fuck he does. Anyway, this has just been our reaction to the incredible verdict. So kudos to the lawyers that obtained this $965 million verdict against Alex Jones and his companies. So I'm Bruce Rivers. Just a quick update on Alex Jones, a little bit of the mechanics on how things work, because if he can't put up a bond, they can execute on it, even though he's going to appeal it. So we'll see you next time here on Criminal Lawyer Reacts. I'm Bruce Rivers. Make sure you sign up, subscribe, follow us on Instagram, follow us on Twitter, follow us on Patreon, and we'll see you next time here on Criminal Lawyer Reacts. Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer. Today we're reacting to Alex Jones and the latest saga as he wanders through the minefield of the Sandy Hook litigation. But before we get to that, this episode is brought to you by eforms.com. That's eforms.com. If you got a project or a legal situation where you need a form of any kind, go to eforms.com. You need a power of attorney, you need a loan agreement, rental agreement, any kind of legal form. Don't hire somebody like me. Go to eforms.com. Don't reinvent the wheel. They've got your back. And look at below, and that's the link. So here's the deal. Alex Jones is above the law, according to Alex Jones. His lawyers just don't comply with discovery. And when you don't comply with the discovery, guess what? You get defaulted. So he hasn't had any substantive jury trials on the issue itself because he won't comply with discovery. And because he won't comply with discovery, he gets defaulted. And when he gets defaulted, then the only issue is damages. So let's just see what he's on the stand here, and let's just see how his statements play.
10 years ago, I thought Sandy would have him.
Robin Parker's sitting right here. He's real, isn't he?
Yes.
And for years, you put a target on his back, didn't you?
Objection to the form of that, Judge.
Well, I mean,
Didn't you?
I've admitted I've said his name. It's true. I haven't said other people's names, but who they are.
You put a target on his back just like you did every single parent and loved one sitting here, didn't you?
So when you are pointing your finger like that and you're going hard like that, it tends to lose, I think, a little. You have the moral high ground on this case, without a doubt. I think you already have it. But I think you can make your point a little more subtly. But listen to what he says.
No, I didn't.
No, you didn't.
That's argumentative. It's speculative. There is no foundation for it. And
So argumentative, speculation, and no foundation. It's not argumentative. He's talking about what he did. It's not speculation. And Alex Jones knows what he did. He's got the foundation for it.
inappropriate.
Let's move on. These are real people. You know that, Mr. Jones?
I think you just told them to move on.
Just like all the Iraqis, but you liberals kill and love. You're unbelievable. You switch on emotions on and off when you want. It's just ambulance chasing.
Why don't you show a little respect? Objection, Judge. I think that if you get what you give.
See, why don't you show a little respect for this court? When you get into this, you can tell it doesn't feel like it when we're just sitting here watching it, but the tension in that courtroom, you can cut with a knife. I've been there when that kind of stuff happens.
Objection.
You have families in this courtroom here that lost children.
See, you have objection, and the judge doesn't rule, but then you go into another question.
Sisters, wives, moms.
Is this a struggle session? Are we in China? I've already said I'm sorry hundreds of times, and I'm done saying I'm sorry. I didn't generate this. I wasn't the first person to say it. American gun owners didn't like being blamed for this, as the left did, so we rejected it mentally and said it must not be true. But I legitimately thought it might have been staged, and I stand by that, and I don't apologize for it.
So I legitimately thought it was staged. I stand by that, and I don't apologize for that. You talk about you need anything more for callousness, lack of remorse, and to pump the damages up even more.
And don't apologize, Mr. Jones. Please don't apologize.
No, I've already apologized to the parents over and over again.
We know
I don't apologize to you.
Objection.
Don't apologize to you.
You're going to do it again.
Objection, Judge.
This courtroom's out of fucking control.
Objection. Objection. Argumentative.
Don't apologize to you.
Well, it's hard for me to get a word in edgewise.
It is, but I
Because
think
your
there's
client
one officer of the court and one witness and an officer of the court heard the objection.
So this judge needs to take charge of that courtroom. I would tell that lawyer, sit down, your objection is overruled. Mr. Jones, you answer the questions, or I'm going to find you in contempt.
And I can't rule on your attorney's. Excuse me.
I'm sorry.
I can't rule on your attorney's objection.
I understand.
Talking, and he may have to adjudicate it.
You're right. I'm sorry. I'm trying.
Because there's going to be another Robbie Parker, isn't there?
Objection, Judge.
No.
Sustained.
There's going to be another.
Objection.
Can I get my questions out?
When it's the same form, second time, the inference is it's going to also be objection.
I didn't say Parkland was fake. I didn't say Uvalde was. And no, okay, so that's a fact.
What did you say about Aurora?
Objection.
What before?
So the lawyer is in this instance kind of being ineffective because he's going off topic.
What did you say about
Excuse me, are you objecting to
I believe it was a real shooting, but he was in a mind control program, just like Theodore Kaczynski. Sorry.
Are you objecting to your client's answers, Attorney
Oh,
Pattis?
that's both the answers and the questions. This is a courtroom, not a trial.
So here's what I'll tell you, Mr. Jones.
Okay. Yes, ma'am.
You're in a court of law. You have to follow the rules as the attorneys do who are officers of the court, and they are accountable to me, and I will deal with them. However, while there were media in the room, this is not a press conference. This is clearly not your show, and you need to respect the process.
I understand.
So when your client's being admonished like that, that's not a good sign.
Whether you like it or not, you have to follow the rules.
I understand, Your Honor.
So just take a breath, have a little water if you like, and wait for the next question.
Judge, I believe there's another admonishment as
Oh, counsel, I'll see you on a sidebar. If I admonish anybody, it's going to be both of you, okay?
If I admonish anybody, it's going to be both of you. I mean, here's the thing. You can't let your emotions as a lawyer get the better of you. It's better to be cold and deliberate and soft and strong, you know, and this judge is fucking pissed.
You're shouting over your client. You just have to stop. Okay, so let's get the next question and let's move forward.
Mr. Jones, there's going to be another mass shooting.
objection.
One word basis. Hearsay, irrelevant, what is it? One word.
Argumentative.
Overruled.
Finally, she takes charge.
Are you saying I'm going to shoot people? Like, how do I know there's been another mass shooting? Like, it's my fault. People think I killed the kids. That's my answer to you.
Let me see if I can ask my question to you.
Sure.
Do you expect there's going to be another mass shooting?
There probably will be.
Do you expect there's going to be another mass shooting? I don't know where that doesn't push the ball down the field. I don't think, and it's really just kind of more sensationalistic kind of a question that doesn't really help anybody.
And when there is, you're going to do it in pounds, right?
Objection.
No.
No?
Relevance.
All right. Why don't you look at your screen there, sir?
See, there's objection, relevance, and then she doesn't rule on the objection. The judge does not have control of this courtroom, although she tried to get it.
Mr. Jones, please.
The problem is that this lawyer fucking hates Mr. Jones badly. And you can tell he's got this visceral hate. And I can understand it. It's really a bad situation that Mr. Jones finds himself in because of his mouth and what he's done with these Sandy Hook people or Sandy Hook victims. But you can't let your hatred for the witness, it clouds your thinking, and all of a sudden you become ineffective.
Yes.
Hold it for everybody.
It's your homepage, right? Infowars.com?
I can't, blow it up, please. Yes.
This is Mikhail Gorbachev, right? He died about 3 weeks ago, didn't he?
Yes.
Why don't you pull up the right side of the page? A little bit bigger, please, just the part survey there. And you're asking your audience that comes to your page to take a survey, aren't you? Correct?
Yes, I didn't write the survey, but.
And the survey is,
good questions.
What will be the most likely deep state false flag ahead of the midterms, right?
Yes.
What's the first option?
The mass shooting, but I didn't write the poll.
Excuse me, sir. Mass shooting?
Yes.
So you can't really interrupt the client or the defendant like that.
And so when the next mass shooting comes, you're already conditioning your audience to believe that it's a fake staged event, aren't you?
Objection. Well, false flag doesn't necessarily mean staged. It means they let it happen.
How many people responded to this survey, sir?
I don't know. I wasn't looking at it. But
That's a good point. He is preconditioning his audience to conspiracy theories, to the next false flag, as he calls
But
it.
there's going to be a mass shooting, and you're inviting your audience, even now, even after all this, to suspect that the next people, the next Robbie Parker, the next family are actors too.
argumentative. No.
It's not argumentative. I mean, it's he can answer the question.
No, I didn't say Uvalde was staged. I said the police did over 77 minutes. And none of the others either. Power grid collapse, terror plot, bombing, COVID.
Right. Could
The
be
U.S.
entities.
government said the Russians.
It could be entities, right, Mr. Jones?
The U.S. government said the Russians staged a false flag to start the Ukraine war, and I believe it.
Right, Your Honor.
Yeah, they're real.
So, Mr. Jones, whatever the next mass shooting strikes, we can be pretty sure what you're going to do, right? Objection. Speculative. Yes or no?
I didn't write that poll.
Speculative. It's asking what he's going to do in his own mind.
But I stand behind it. I've never seen that poll, but I think that's a reasonable question.
I'm done, Your Honor.
So this is just a little snippet of how the proceedings are going in the Alex Jones, and he doesn't present as sympathetic at all. So we'll see they haven't gotten to the damages phase of it, but so we'll see what happens with Alex Jones. So this has just been our little critique, or not critique, but just our observations of the courtroom antics, and they were some fireworks going on there. So I'm Bruce Rivers, Criminal Lawyer Reacts. Thanks for watching. Make sure you subscribe, like, follow us on Instagram, follow us on Twitter, and we'll see you next time here on Criminal Lawyer